Hello, this is UCL Uncovering Politics, and this week we ask, who or what is really responsible for structural injustice, and what can the law do about it? Hello, my name is Emily McTernan, and welcome to UCL Uncovering Politics, the podcast of the School of Public Policy and Department of Political Science at the University College London. When we see injustice in the world, we tend to look for someone to blame and hold to account. A corrupt official, an unjust law, some bad actors. But some of the world's most enduring injustices, perhaps climate change, homelessness, systemic racism, and the patriarchy, don't have such identifiable villains, no obvious bad actors, no single law to strike down. Instead, they are what philosopher Iris Marion Young calls structural injustices, wrongs that emerge not from individual malice or from an unjust law, but from the everyday workings of our social systems, shaped by countless individual choices, economic incentives, and various norms. And at first glance, that doesn't seem like the kind of problem the law can fix. After all, how can you legislate against a structure? But what if we've misunderstood the power and the potential of the law? That's the argument of our guest today, George Letsis, Professor of the Philosophy of Law here at UCL, who offers a bold vision of how legal systems might be to blame and could be the fix for structural injustice. Welcome to UCL Uncovering Politics, George.
Great to be here. Thank you for the invitation.
Let's start with the basics, but something that's created an incredible amount of philosophical discussion. What exactly is structural injustice?
So, first of all, it's a term that Iris Marion Young coined in her book, Responsibility for Justice, which has been very influential, so much so that it also became massively influential in law. So lawyers now are getting interested in the idea. And roughly, the idea is that there are wrongs that are the result of patterns of behavior by all of us, which cannot be attributed either to individual actors or to policies by the state, including, of course, legislation. So what the idea tries to capture is some sort of collective responsibility for injustice, where, like you said, you cannot really pin it to a blameworthy agent, nor can you identify a law and say, that is an unjust law.
And the classic case, and the case that guides the piece of work that we're talking about today, is the case of Sandy. Can you tell us about Sandy?
Correct. So Sandy is the example Young uses. She is a single mother with 2 kids on a very low income. And she struggles because she's trying to find affordable childcare and she cannot. She's trying to find a job closer to where she lives and she cannot. The result of this struggle is that she's been evicted. Estate agents are not very helpful in helping her find a new place. And through all these patterns of behavior by her employers, by the property market, by the estate agent, by childcare providers, she ends up being homeless and living in her car. And the idea that Young wants to motivate by this example of Sandy is that she ends up in this very vulnerable situation of homelessness without it being the case that anyone has acted unjustly. Neither the employer, nor the landlord who evicted her, nor the childcare providers. None of them really did something blameworthy, nor is it the case that laws on property and eviction and employment are in themselves unjust. Nevertheless, there's something wrong about her situation. And the moral of the example is that what's happening here is that everything we did, the way we exercised our freedoms, the way people in her town live, their actions and patterns of behavior, what kind of jobs are available and property. Everything that people did around Sandy had the causal effect of making her vulnerable to homelessness. So the conclusion is that there are wrongs out there that Young calls structural, for which we're all effectively to blame, even though none of us individually did anything wrong.
Great. And so let's get the tension as well between structural injustice and the law on the table. So the view that you're arguing against in your paper is the view that the law's not doing much to contribute to the kinds of problems that Sandy and others are facing, and it can't do much as a solution either. So why do they think that?
So as a lawyer, I was struck reading Young for the first time because she begins with the premise that this is not really a legal problem. And it's not a legal problem at many different levels. So first of all, she claims it's not the case that there's any legal responsibility individually. And so if you look at the landlords, he or she had every right to evict someone who doesn't pay the rent, is behind on the rent. Look at the employers, they're not really legally responsible for providing free childcare to Sandy, for example. And the idea there that law is only a small part of the structures of the patterns of behavior that resulted in homelessness. It's such a tiny part, and it's not the case that law can actually do much about it because it's premised on what Young calls an individual model of liability. Now, I want to explain what that means. In Young's mind, and for many people who work in that tradition, when we talk about legal responsibility, we're really talking about some interaction or wrong. So there's two people interacting with each other, landlord versus tenant, employer and employee. So there's always two persons in the equation. And unless you can say that one of them is legally liable for something, then you cannot really attribute any legal responsibility. So for Young, law is only a small part of what causes the vulnerability, but also it cannot be part of the solution because the solution requires some changing those patterns of behavior. And all that law can do is tell the landlord, you're liable for something, or tell the employer, you're liable for something. But both cases would be such a minor part of the picture. So by its nature, Young thinks, law is very limited in the way in which it can address that wrong. I should also say here that Young thinks that the legislation in place in the example, so legislation around property, around employment, are not unjust when you look at them. And that's something I want to query later on. But her view is that, look, there's nothing wrong if you look at eviction or employment law. It's not as if it's evil laws like a law mandating slavery or something. Because, on the face of it, they seem neutral. They don't really seem to be anything wrong with them. Many legal systems have it. So you cannot really say that the injustice inflicted on Sandy is the result of some evil law. And that's why she takes a very narrow view of the law. And that's exactly the picture I want to query.
Great. So to be structural injustice, it can't just be a single unjust law. Otherwise, that's just normal injustice or something, not this special type. And you're saying as well that the trouble that she's having with the law is it's something like there's no perpetrator here, right? There's not the landlord egregiously violating all of the laws around here. Then the law could come after him.
Correct.
Everyone's just working within the system, making their patterns of choices. Here's our injustice. What are we going to do?
Correct. So in a way, it's she assumes that the legal model or the way law works is a very individuated methodology whereby it's either a person responsible, not a structure, or it's a particular piece of legislation you can point and say, well, that law is unjust. And neither of those is the case here.
Great. Let's get started with why she's got the law so wrong. So one of the claims you make in the paper, provocatively, I think, is you say the law is ubiquitous in social structures. So what are you meaning when you say that?
Good. So one wouldn't be surprised if legal philosophers want to aggrandize the role of law and see it everywhere. But I want to explain what I mean by that. So I think I should start with the idea of a structure and what we mean by that. So the way Young and other political theorists use the term, as far as I can understand it, is as patterns of behavior. So things that people do. And it's not just on a particular occasion of a particular person doing this, but you can identify similar forms of behavior across different groups in society. So there's massively people doing things. And if you look at the way law relates to those structures, you might take a very narrow view on the law and say, well, sometimes people follow a particular law and they're guided by it. And that might be a pattern where law has something to do with it. But a lot of the time, people don't even know what the law says about something. So there's just two things. So a business might decide to move from London to Manchester because office space there is cheap. And they might not think about the law at all. They might just make a market decision. What I'm trying to say is this, that anything people do has a binary connection to law. Either the law permits it or the law prohibits it. We might not think about the law when we do things. Like I came out of my house this morning, I came here to do the podcast. I didn't think that the law was relevant to what I did. However, coming here meant I exercised my legal right to freedom of movement. If you had tried to stop me coming here, I would have called the police, complained about interference with bodily integrity, the number of torts and criminal prohibitions around that, and the police would have stopped you from interfering with my liberty. Same as you've tried to enter my house. I would have called the police. In fact, I locked my door so you cannot get in. All of these actions have a legal valence, so to speak, are legally relevant. Either the law protects me or the law allows you to interfere with my freedom. Now, this, I think, is important because for any pattern of behavior, it's either the case that you can get legal officials to protect people engaged in that pattern, or you can get legal officials to frustrate that pattern.
So the law is everywhere, all the time, controlling everything. So when I read this moment in the paper, and this is really important for getting to grips with Young, and we'll get back to the Young and the structural injustice in just a second. When I was reading this part of the paper, I thought, okay, it might be formally true that everything we're doing here is either permitted or forbidden by the law. But it's not effectively so, or it's not in practice, though. So the law, we already know that, right, the police are hugely overwhelmed. The law courts have 4 or 5 year backlogs for any case. The law's not really controlling everything that we're doing here, is it?
Good. I think it's crucial how to understand control. So one way to understand control is the way you just implied, as guidance in the decisions and actions we take on a day-to-day life. And that, I think you're right. I mean, I'm a lawyer. I very rarely know what the applicable law is in the stuff I do. I only go and look it up if there's a problem. If someone sues me, if someone's trying to stop me. So that is true. It's not ubiquitous in that sense. It is nevertheless the case that the patterns of behavior settle or get frustrated because of legal action. And therefore, the possibility of enforcement is always on the cards. And that ultimately affects both what kind of freedoms people exercise and what they do, but also how these patterns change over time, because all it takes is some case where someone challenges a pattern, the case goes to courts, and the court says, well, actually, evicting a tenant when they will end up homeless, that's a pattern we used to tolerate. But now, looking at the principles of law as a whole, we realize that this would be, say, inhuman and degrading treatment.
Great. And so that leads us nicely back to Sandy, the mother who might be made homeless. Is your claim here that given that the law is doing all this stuff in us, in those social structures that seemed really nebulous, are actually all about the law, is the law responsible for her situation, in your view?
I think so. So that gives us a broader overview of the patterns whereby the way law assigns rights and duties becomes relevant to the question of structural injustice, because this is actually causing the various patterns. And then we can, I think, get a better grip of the insight of Young, which I think is very important, the collective responsibility. So how do we allocate rights and duties? And I think here what I want to insist is in the binary nature of the patterns. Either the law frustrates a pattern or it protects it. And the question of which is the right way for law to go is very important and has to be looked at case by case. So in the case of eviction, in the case of employment, in the case of childcare, we have to look at whether the law allocates the responsibility in a way that protects a pattern that we shouldn't be protecting, and we should be frustrating that pattern or not. So it gives us a more general idea, a baseline, if you like. Is the baseline fair or not? And that retains from Young the emphasis on collective responsibility, by which I mean, if we are frustrating those patterns through enforcement, that's a state action. That's an action for which everyone is responsible. It's not really the landlord, the employer, or the tenant. It's the way we have allocated those freedoms. And we can make a judgment about the baseline. Is this a fair baseline to have? Should we reallocate the rights and duties such that the patterns will be frustrated? So that, I think, for me, is very important. And what I call the ubiquitous nature of law really wants to shift the emphasis away from an impersonal character about structural injustice. It's stuff people do, and no one's responsible except everyone is responsible. And look more at the baseline. How we allocated rights and duties in a way that we can safely say it's a fair and just way of allocating rights and duties and responsibilities. For political theories, that's not really so clear. In law, it's always been the case that the allocation across the board of people's rights and duties in law brings with it a combination of principles of interactional justice. So, say, contract. You and I have a contract. If you breach, it's only fair to say you are liable, personally liable. But also, it brings broad issues of social justice. Like what happens when you breach? Do I get you to perform, or do I get you to pay compensation? That question is no longer just a question about interactional issues, but it will have to make assumptions about what kind of market we have. If you pay me compensation, can I get someone else to do what you promised? And how does the market in the background change the obligations people have towards one another? So, for example, consumers, I'm not talking really about a typical promise here where you promise to do A, therefore you have to do A. Consumers are more vulnerable against manufacturers. Manufacturers are powerful. So the law there recognizes and departs from principles of interpersonal interaction and protects the consumer. And that is exactly as it should be, precisely because law's purview, if you like, the scope of law's interest is way more broad than interaction between individuals. It's looking at issues of social justice across the board. And it does this, I think, in every area of law. That's why I think the claim by Young that, oh, you just look at one particular law or one particular interaction.
So eviction. And you say, oh, that seems okay.
Exactly. You cannot really say that eviction is okay unless you look at the broader issue of social justice in the background. So, for example, it's not clear to me that the property laws we have are appropriate given the patterns we know. So, there's no affordable housing in many big cities. Renters suffer; they cannot find affordable housing. They are vulnerable to eviction, like Sandy is. And it's all to do with a system of property whereby it allows owners of property not only to enjoy their own possessions, but also to exploit it in the market, buy to lets, make profits. And it's not obvious to me that that kind of pattern of allowing the market liberty of landlords is justifiable.
Great.
So you can have a country like Sweden where the government is trying to create a public housing scheme, but that keeps costs low because you just apply, you're in a queue until a high quality of affordable social public housing is available. It's not means tested. Everyone can use it. But the effect of that, ideally, is that you don't create a market where landlords can use their property to make a profit. And it keeps property costs down and it prevents likelihood of eviction. So that system of property, right, of land property, is way more conducive to battling the harm that happened to Sandy. So as a European, being aware of renter-friendly legislation in many countries, I look at the story of Sandy, I'm thinking, well, no, there's a lot that law can do about this. Because actually, if you look at it on the other side, what's happened in the countries like the US, the pattern that Young is worried about is in effect the result of law, because law there has failed to provide all this protection to the tenant.
Great. The opposition then is Young has fundamentally got it wrong about Sandy. It's not a product of this diffuse structure where there's no one to blame or something like this. And so we're all kind of responsible and forward-looking way and we have to fix it together, but there's no one to blame. You're actually making quite a sharp distinction to have you. Is that right?
Correct.
The law's to blame. The American law is unjust.
Correct.
As a mass, not an individual law, but as a collection.
Correct.
And the Swedish law, for instance, is just.
Correct. And there's another way in which I depart from her analysis because, and that I think is important to highlight for our listeners. I think when you are a landlord who is looking to make a profit by owning property that they may have bought with the purpose of making a profit, and you evict a tenant like Sandy, it's not only the case that there's injustice in the background scheme of legal rights that allow you to do that. I think also there's individual liability. So the landlord who's doing this in the knowledge that it will lead to homelessness, I think that person is morally responsible. But also I'd like to think that potentially they're legally responsible, because if the principles of the legal system clear enough that this is incompatible with the values of the legal system, then I think courts should have a look at this. And maybe it doesn't happen yet, but there's examples where this happened, where the courts turn around and say, we've been protecting landlords' liberty to evict for so long, but in this case, given the risk imposed on the tenant and given how extreme the vulnerability is, we might decide that they don't really have this right, and that the landlord is now responsible has the duty not to evict. So I want to also say that actually there's still space for individual responsibility.
You're pinning it on the landlords as well. So you're saying actually this is one thing that interested me about your paper. You like to keep the term structural injustice. So even at the end, you're talking about how the law can fix structural injustice. And we'll get to some of the positive suggestions that you make in a moment. But in fact, it seems to me like you're saying this isn't a structural injustice. So as a political philosopher sitting on the other side of the table, I'm thinking, right, okay, now I've got an individual wrongdoers. I've got these landlords. And it turns out that it's not this diffuse effect of a structure where no one's a wrongdoer. It's just the law. And the law is ultimately something the government has responsibility for. And then we do it for electing that kind of government that produces that kind of legal system. And so we're not in the terrain of forward-looking responsibility and diffuse structures. We're in the terrain of individual liability and wrongdoers.
So, Emily, I fully expected that you'd put me on the spot for my philosophical argument in this paper, as it happened so many times in the past in our interaction. So I did wonder whether my account is actually critical of the concept of structural injustice, because you're right, I do identify specific laws, or if you like, bundle of laws. It's not just one piece of legislation. I think that's very important. It's a host of legal rights and duties around commercial freedoms, property, employment. So we have to look at the law in general, not just particular areas. But having said that, I am very specific about what is causing the injustice. And that seems to be against what Young wants to say. So initially, I thought maybe I shouldn't use the term structural injustice. Maybe what I'm arguing is against structural injustice. But having said that, one thing that I agree with Young, and that's why I retain the term, is that this is collective responsibility, not just individual. We're all responsible for the kind of coercive enforcement that happens in the name of the community. That's, I think, something we often forget, that legal enforcement is not just government passed a law, could be a right-wing government, left-wing government, so it's their law, and then officials enforce, so it's officials doing the thing. When law is enforced, it's in the name of everybody. It's in the name of the community. So even if we had little input or say in how those laws are shaped, it's still our law. So we are all responsible. I think that's what is important about Young's account. And I'm trying to give a way in which this can be explained in a more concrete way, such that we can do something about it. Because the way Young presents the issue worries me. We throw our hands in the air. Everybody's to blame. It's patterns of behavior. A single change by a single person or a group won't change much. So, it's desperate and nothing can change. Whereas if you think about structural injustice in the way I propose, things can change. And it's not just legislation. As a lawyer, I think what's more important here is courts. Because the kind of arguments that I think should be made for people who are victims of structural injustice, like Sandy, really take place in court. They take place where someone goes to court and says, look, there are all these principles underlying our laws. And if you really look at them in their best light, they don't seem to be authorizing what's happening to me. Right? And then the court will say, actually, that's fair. And it's our job here to make sure that the baseline, so the principles that underlie all of our laws, are coherent and make sense, and people can get behind them. So that's why I think the role of court is way more important than the role of the legislature. And actually, this is where citizens can have more voice, because you can make the argument in court and say, look, how is it possible that homelessness, as a result of this bunch of legislation, is something that our legal system can tolerate? And they can have their day there and make their argument that they couldn't have made it in Parliament when legislation is being debated.
And this is one of the fascinating parts of your paper, is this kind of argument you're having that political philosophers have kind of got it wrong where the emphasis is, right? So the thought is standard political philosophy. What do we think about? We think about what the state can do, what the legislation might be, the kind of major institutions. And here, I guess you're drawing our attention to the salience of the court, the moment in court, the ability for an ordinary citizen to make their case, and for a set of judges to decide the law needs to be reinterpreted now. These are the values that we're really committing to. Are you worried that this seems a little... So I guess there's two worries you might be presented with, right? So one would say something like, this is a very activist role for a court. They're not a democratically elected body. Should they have that kind of control over the legislation being interpreted in these ways? If the government didn't mean it that way, they wanted to protect the landlords, and now suddenly a court turns around and says, you know what, let's not let these kinds of evictions happen.
Good.
Is that overstepping their duty?
Good.
And then the other challenge I wanted to present to you is what about this? You have this lovely idea of the ordinary citizen takes it to court and fixes the problem. But of course, as a lawyer, lawyers are very expensive. It's not the case that even I can take a case to court. If UCL treats me badly, I've got very little ability to take them to court, right? They have so much more money to buy the best lawyer. I have none of the money to buy the lawyer. They're going to win even if I'm morally right.
Good. Well, first of all, I can help you if this were to happen in a likely scenario.
Brilliant. I've sorted myself out a lawyer.
For free, I should say. But on your first question about the relation between courts and the legislature, I think one thing I should say is that the way legislature reacts and tries to deal with social problems like homelessness or deprivation is by nature very sporadic and fragmented. Legislation cannot anticipate all kinds of ills and problems. It's reactive, it's trying to deal with problems as they appear. And inevitably, if you think of legislation, it will have gaps, imperfections, and inadequacies. No legislator can predict the future. and have a comprehensive view of all the problems. So that's as it should. That's why its role is not really the same as courts. Courts don't try to fix problems in a forward-looking way. What they do is try to identify what principles underlie the legislation such that all the possible gaps, imperfections, and inadequacies are ironed out. So it's not as if they're competing for the same role. That's why it's not really a problem the courts are not elected, because their job is not really that. Their job is to make sure that whatever principles we have identified through democratic process are across the board coherent. And that's why I think there's no really concern about the democratic mandate. They have a different job. Now, it's also the case that, what kind of ideas should we have about law? The narrow one of the legislation that's full of gaps and inadequacies, or the wider one when the case goes to court, where the judge has to be, in a way, have a broader view and say, well, this person now is claiming something, an injustice. Can the law really tolerate this or not? So it's a broader view, and I like the broader view because it allows us to deal with problems more effectively now at the level of principle. And that's, I think, why it's so important. But you're right, cases go to court exceptionally, and for them to go to court, it takes money and time and effort. But I think what we're looking at the moment, at least, is that there's a lot of social change happening through courts. My own area of expertise is human rights law. And I have to say, the last 60 years, human rights law has been a positive force for good in social justice in Europe. It has resulted in reform, large-scale reform in many countries. The European Court of Human Rights not only finds violation against governments for individual wrongs, but often says the problem here is legislation. The problem here is inadequate legal framework. And this has resulted in large-scale reforms in many countries. And of course, you're right, some have to be the lawyers who take the case. A lot of them do it pro bono, as I have done in the past in the European Court of Human Rights. And many of the bigger social problems now are being tackled through courts. So climate change is one. There was a big decision of the European Court of Human Rights on climate change last year against Switzerland. And what the court said there was, and actually the problem here is that the country is not taking enough action at the level of legislation to cut CO emissions. Now, the difference with that case is that it was heavily funded. So there was a lot of money behind this. So it was well funded and brilliant lawyers behind it. And Sandy wouldn't be that case. People like Sandy wouldn't necessarily know that they could do this. But my response to that is, let's get the word out there. Let's get the word out there. My plea here with this paper is that people should be aware of this option, and things can change, and we just have to help those people using law. It's possible. The alternative is to despair, it seems to me.
Great. So you're saying Young's wrong. There's definitely a way to fix structural injustice. We can have better legislation like Sweden, and if we don't have it yet, go into the court of law and get it fixed. That's the claim, right? Homelessness you describe as one point as a legal condition, right? It's the kind of thing you could fix through the law. There's one other bit you put on the table as a kind of source of hope. You mentioned the idea of legal status. Could you explain briefly for our listeners why that's one more bit of the toolkit that we have here in the law to fix these structural injustices?
So this relates to a project I've been working for a long time now, and it's a book that should be coming out this year on the idea of legal status. And it's an idea that has been around for centuries. And lawyers use it mainly for legal relations that are marked by vulnerability or dependency. So think about very many of the well-known legal status, being a refugee, being an employee, being a tenant, being a minor. The law there recognizes that there is a pattern of behavior that results in vulnerability for specific social positions. And what the law does there is equip the status holder with a set of rights that can help mitigate that vulnerability. And I think we have forgotten about that idea. And I think that's partly the result of neoliberal policies, freedom of contract, freedom of commercial enterprise, where we lost sight of the vulnerabilities that people inevitably will face in the market economy. And the idea of legal status withdrew, and I'm trying to get it back on the table and call for more statuses to protect people in vulnerable positions like Sandy. So tenancy is one. I want it to be a clear legal status that has a lot of protection.
So the idea is I'm a tenant, here are all of my rights now against the person.
For example, rights against eviction, possibly rent control, or regulation against spikes in rent increase, which are happening across the country. And the idea of status gives people this legal protection they need. And we need more of those. And, I don't want to give like a fixed list of statuses, but I think if we're to go back to Sandy, imagine her situation in a different world where employment status in the US was protected in the way it is protected in many European countries like France. Imagine if her tenancy status was protected in the way it's protected in Sweden. Imagine if her status as a parent was protected, where she would have free childcare. And all these are statuses Sandy holds.
They're what make her vulnerable, I suppose, to the situation that she faces.
Exactly. So I'm calling for the legal recognition of systemic vulnerabilities through the national status.
That's fantastic. What a positive vision of law. I'm going to ask one last question before we wrap up, and one last slightly challenging question. So I have to admit, when I read Young, I thought homelessness was a really poor choice, precisely because you can see all of the legal structure and various individual choices that have led to that situation. The landlord deciding to do this, the other landlord not renting to her, and so on. Do you think the ORA account's going to apply to structural injustices that don't look?
Can you give an example?
So I guess this is the funny thing about structural injustices. I realise now that political philosophers are using it so generally. It seems almost everything counts as one these days. But, you might look at things like, you mentioned climate change. Do you think maybe there's some legislation that can go there? But even, let's take the case of climate change. Even though you've suggested the law could do more, you might think that climate change is a kind of structural injustice where the law alone just really isn't going to do it. So even if we pass lots of laws about emissions, we've got a fundamental problem about the way we've structured the economy that's going to be very hard to get to through the law.
Good. So there's two questions there. One is a question of efficacy, like will changing a few laws get us to where we want to be, or will it require some more radical legal reform that no state is willing to do so? So there's a question about incentives there. And even if you get the courts involved, like the European Court got involved in the case of Switzerland, cannot have the impact we wanted to have, which is all states now realizing, we may be legally liable. That's shit. So we know things don't work like that often, and we know also know that states ignore many times court rulings because, particularly with international law, there's no enforcement. So that are all problems. But I think you're right to say that not all problems of structural injustice are the same. And as I say in the paper, there might be cases where court action or even legislative action is not enough. So I don't want to say that everything can be fixed by the law. And I think that would be sort of a too utopian or optimistic approach. But I do want to say that most of the things that Young talks about can be fixed. So I want to leave it open. There might be cases, racism is one example as well, where it's not just about, say, changing the culture in the police force, educating police officers, changing institutional action. That could all be happen with the help of the law. But it's also how individuals behave in their day-to-day life. And this can only be tackled if these patterns get changed. And there's only the law can do to make people behave better in their private lives, for example. So there are notions of structural injustice that are so wide, and their law would have little to say. But I think I take the insights and the influence of Young to be the one that it was, precisely because it captured or tried to address some pressing social problems like homelessness, like climate change, like racism. And I think we shouldn't overlook the fact that there's so much law can do for those things. Maybe it cannot fix everything, but it can fix a lot.
Thank you, George, for coming on and giving us all some hope that maybe the law can be a force for the social good, and maybe the structural injustice stuff that political philosophers have been talking about isn't nearly so intractable as we'd been assuming. So we've been discussing George Alexis's recent chapter, Structural Injustice in the Law, a philosophical framework, published and open access to all through UCL Press in a wonderful collection on structural injustice in the law. As ever, you're going to be able to find details and links to that in the show notes. Don't forget to subscribe to UCL Uncovering Politics on Apple, Google Podcasts, or wherever you listen to stay up to date on our latest episodes. And if you enjoyed today's conversation, please take a moment to rate or review us. It really helps new listeners to discover the show. I'm Emily McTernan, and this episode was produced by Eleanor Kingwell-Banham. Our theme music is by John Mann. Thank you for listening to UCL Uncovering Politics. See you next time.